The Justice Department wants to take over President Trump's defense in a defamation lawsuit. Last year, columnist E. Jean Carroll accused Mr. Trump of raping her in the 1990s. President Trump responded to the allegations by saying she was, quote, totally lying to sell a book she published. She's suing him for saying she lied. Today, Attorney General William Barr defended his department's decision to intervene in the case.
So this was a normal application of the law. The law is clear. It is done frequently. And the little tempest that's going on is largely because of the bizarre political environment in which we live and well, I'll just leave it at that.
Let's bring in Loyola Law School professor Jessica Levinson. She's also the host of the Passing Judgment podcast. Jessica, thank you so much for joining us. We heard what the Attorney General said there. This move, though, would mean the government is defending the president at the taxpayers' expense. The Attorney General said this is a, quote, normal application of the law. Is it?
It's a normal application of the law if the President of the United States is acting in his official capacity. So if the President of the United States was sued for defamation because of something he said while signing a treaty or while signing a bill or while negotiating with a foreign government, then yes, that would be pretty normal. But what we're talking about here is the President of the United States, in my opinion, making a personal statement about a personal activity. So the statement, as you said in the introduction, at issue is his denial that he sexually assaulted Ms. Carroll. If that denial is in fact false, it can be a defamatory statement. And this is not, again, a statement that he made with respect to his negotiations with a foreign government, whether or not he's going to sign a bill, a piece of legislation, even an executive order. This is about an action that was alleged to have taken decades ago with respect to, again, not an action based on official duties. And what the Department of Justice here is saying is that when he denied that sexual assault, that was part of his official duties. That was in his official capacity. I think that is a significant enlargement of what we view as official duty or capacity.
So Carroll's attorney called the government's position, quote, shocking. Is there any precedent for this?
Well, again, certainly there is precedent for the Department of Justice coming in and saying we're going to defend a federal employee because there is a federal law that says federal employees can be immune from defamation suits based on official duties. I have never seen a corollary where the Department of Justice has stepped in and substituted themselves for the president's private law firm based on actions that I believe were taken in President Trump's personal private capacity. So no, there is not, in my mind, precedent for that. That is what is qualitatively different here.
Well, last month, a judge denied a request to stay the litigation, which meant President Trump may have to produce documents and a DNA sample and sit for depositions. Now a federal judge will decide whether the DOJ can intervene on the president's behalf. What changes about this case if the DOJ's filing is successful?
Well, if the DOJ's filing is successful, there's basically two hurdles that we need to look at. Hurdle number one, did the Department of Justice properly remove this to federal court, meaning change the venue? And that probably they do have the right to do so. Hurdle number two, does the president get this immunity because he was acting in his official capacity? I'm not at all sure that that is the case. But if the federal judge finds that it is, then this case is over. And what that means, as you said, is so significant for President Trump. It means he does not have to produce DNA evidence. He doesn't have to produce documents. He doesn't have to sit for a deposition. And that's what he really doesn't want to do. And we know that these defamation cases based on allegations of sexual assault are really kind of a backdoor way of litigating the sexual assault claims. Because again, there's only defamation if President Trump was lying when he says, I didn't know her, I didn't sexually assault her. So it's a way of trying to get to the truth of those accusations when the statute of limitations has run on the underlying crime, the underlying sexual assault.
All right, we will continue to watch it. Professor Jessica Levinson. Professor, thank you so much for sharing.